night on the CINA 102.3 app at CINAFM.com, on TuneIn, on Smart Speaker, and at 102.3 FM. CINA Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of CINA Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. مساء الخير مستمعينا، تحية طيبة لكم وحلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز المختصة بحوادث السيارات والإصابات الشخصية، تأتيكم على الهواء مباشرة عبر راديو سينا 102.3 FM. بإمكانكم المشاركة في الموضوع المطروح في الحلقة عبر الاتصال على الأرقام 313-769-6666 من وينزر كندا 519-256-1023. تحية طيبة لكم وأهلا وسهلا بك جومانا مرة أخرى في راديو سينا.
صباح الخير رامي، يعطيك العافية.
الله يعافيك، أهلا وسهلا.
نهار جميل جدا اليوم.
رائع.
نحن مسكرين شوي اليوم لأنه الشمس
لأنه مايك حابب يأخذ صور يمكن.
Is that what it is? Mike, why do we have the shades closed behind you? Is it because you want to take pictures or is it because the light is reflecting?
It's mostly for the pictures, but also this time of day my back really starts to roast because the sunlight comes right in the back of me.
أكيد الطقس حلو والشمس مشرقة، وأكيد وجودك اليوم معنا جومانا والمواضيع اللي تطرحها دائما في برنامج يور رايتس على راديو سينا 102.3 FM. نتمنى تكون دائما الفائدة لمستمعينا. واليوم أعتقد الموضوع راح يكون أيضا عن البانكربسي.
Yes, upon popular demand, we have Attorney Michael Benkstein, who heads the Department of Bankruptcy in our office here. And today we're going to talk about a number of issues. I'm going to translate very quickly in Arabic and then give the floor to Michael today. أول سؤال رح أسأله يا رامي، مثل ما بيقولوا بالإنجليزي are all bankruptcy lawyers created equal؟ هل كل محاميين البانكربسي متساويين؟ يعني هل إذا رحت أنت عند محامي بيعرف القانون هل هيدا كافي؟ هل كلهم مثل بعضهم؟ ولا هل قانون البانكربسي يعني شو بيقولوا بالعربي الإفلاس، بعتذر، قانون الإفلاس هل بيتطلب ذكاء أكتر، طريقة تفكير معينة، thinking outside the box مثل ما بنقوله؟ هيدا سؤال من الأسئلة. تاني وحدة بدنا نرجع نذكر المستمعين عن نقطة كتير مهمة عملناها أو حكينا عنها الأسبوع الماضي واللي إجينا عليها اتصالات بالمكتب. كتير عالم ما بيعرفوا كانوا، وأنا وحدة منهم، إنه وقت اللي بتقبض من الحكومة SSI، إذا بتفوت على البنك أكاونت اللي بتحط فيه SSI payment مصاري من أماكن أخرى، في احتمال لا سمح الله إنه يقدر حدا يحط إيده على المصاري إذا أقام دعوة ضدك وصار في garnishment. ثالث نقطة بدنا نحكي عنها اليوم، موضوع كبير اسمه هل دائما الحل هو إفلاس يعني bankruptcy إن كانت chapter 7 أو chapter 13، ولا هل في أوقات حل آخر بيسموه debt negotiation؟ رح نحكي عن هالموضوع بطريقة مفصلة كتير، ونتكلم عن مثلا بعض الانستيتيوشنز اللي ما بيقبلوا debt negotiation، يعني غير وارد معهم انه تعمل debt negotiation. فهون بتعرف انه الحل وحيد لك هو bankruptcy إن كانت chapter 7 ولا chapter 13. رح نحكي عن ال income tax returns وقت الإنسان owes the government taxes. هل هيدول are dischargeable in bankruptcy؟ وإذا منهم dischargeable in bankruptcy هل محامي الإفلاس بيقدر يساعد الشخص ليخفض البيمنت أو يحط البيمنت on hold؟ والجواب هو yes. وخامس نقطة اللي حنحاول نتكلم عنها هو student loans، ويمكن العالم كلها بتعرف إنه student loans منهم dischargeable in bankruptcy، بس هل هيدا بيعني إنه محامي الإفلاس ما بيقدر كمان يوطي البيمنت؟ يعني لنقول مثلا تلميذ عم يدفع $500 بالشهر بس لظروف معينة، هل بيقدر البانكربسي لوير يساعد هيدا الشخص ينزل البيمنت بلان أو البلان أو يحطهم on hold لمدة معينة؟ والجواب كمان هون يس أو إيجابي. we have a lot to go over today. And everybody knows the number here. If people want to call, I understand a lot of people don't like to call and talk about their financial situation. People know that their voice may be recognized. I also know that a lot of people don't like to call and talk about their criminal situations and about their domestic situations. So we expect when we talk about these subjects on the radio that we are not going to have a lot of callers. And that is why we monitor very closely the calls we get in the office. And that's how we have our finger on the pulse of what people are asking about, what people are confused about, what people need education on. And that's how we pick the subjects for what we talk about on the radio to tens and tens of thousands of listeners. Attorney Michael Benkstein, who heads the bankruptcy department in our office, are all bankruptcy lawyers created equal, so to speak? Yes, no, why, and why not? And please be specific, because we don't want to sound like a sales pitch. It's not.
Marhaba, Joumana. All bankruptcy attorneys are definitely not equal. If you walk into a bankruptcy attorney's office and you talk to them for 10 minutes, and after 10 minutes, they think they have you all figured out and they have the answer after 10 minutes of sitting down there, run, don't walk away. They are definitely cutting corners. There's many fine bankruptcy attorneys out there, but there's plenty of people who really try to do the paint by numbers treatment, and your life is a unique thing based on a number of factors, but even your financial life is based on a unique combination of your income, your expenses, your assets, your liabilities. This is not a pulling it off the rack at a department store approach. It's tailored to your specific situation. I can think of at least 4 very common things that I've heard about from other offices, which shall remain nameless. One, somebody comes into a bankruptcy attorney's office and they have credit card debts, but they also have income tax debt. Oh, well, no problem. The income tax debt.
What do you mean by income tax debt? That they owe the IRS
to the IRS, for
or
example,
the state of Michigan taxes?
Correct.
Okay.
So, for example,
and that was a situation you had yesterday when someone called who owes the IRS taxes.
Right, and he was thinking of doing a payment arrangement and then doing the
with the IRS.
With the IRS, and then doing a bankruptcy. Well, I told him, not something that every bankruptcy attorney would tell you necessarily, is that there's no point doing the payment arrangement first if it also makes sense to file for bankruptcy on the things that you can file for bankruptcy for. Because if you put a payment arrangement together with the Internal Revenue Service and then you file for bankruptcy, the filing of the bankruptcy will undo that payment arrangement.
So why wouldn't other knowledgeable bankruptcy attorneys give similar advice?
Well, I heard of a situation several years back where there was another law office where a guy owed over $100,000 to the IRS.
Okay.
And he did have some credit card debt. It was probably a little over $10,000. But he had a payment arrangement with the IRS, and he was only paying about $109 a month, which is a really good deal.
With the IRS?
With the IRS. That other firm filed him for a bankruptcy, kind of missed the issue, filed him for a bankruptcy. So
what issue is to miss? He had already previously entered into an
a
agreement.
Arrangement.
Yes, with the IRS.
The problem now is you filed for bankruptcy, and the filing of the bankruptcy undoes that payment arrangement. So sure, now we know that $10,000 is going to be taken care of, but now you've reopened that $100,000 can of worms with the IRS.
Okay. Give us another example of how not all bankruptcy attorneys are created equal. I think the point we're trying to make across here is that, you may know bankruptcy law, but that is not sufficient. You need experience. You need to think outside the box. There is no cookie cutter answer. Everybody's situation is different from the next. You need to listen to what the situation is. You cannot understand what people's situation is without spending a good hour to an hour and a half with them. About an hour is what you're telling me to really understand it. And you're saying that without, mentioning any names, of course, a lot of other bankruptcy attorneys may cut corners, and to make it more cost effective for them, they don't give that kind of attention.
That's absolutely correct, Joumana. You know the old saying that if you're a hammer, everything's a nail. Even though I've been doing bankruptcy for the last 11 years and I've helped thousands of people through that process, I'm not going in there with the mindset that I must sign you up for, I must sign up X number of Chapter 7s this month, or this number, I have to put a couple more people into a Chapter 13. No, it's based on what's the best fit for you.
Okay. Well,
here's another example that you were asking for, just to work this in here. This is very common too. Payments to family members. So someone borrows money from a family member. Let's call him Cousin Sam. And they borrowed $1,000. And then now they're thinking, well, I'm about to file for bankruptcy. Let me pay Cousin Sam back the $1,000. And then a few months later, they go to a bankruptcy office. That bankruptcy office, if they're the 10-minute guy who blows through all the issues and signs you up for a bankruptcy, well, that's a problem, because one of the things that a bankruptcy attorney, that the bankruptcy court looks for is, have you made a payment to an insider, that's someone related to you by blood or marriage, within the year before the case was filed? They don't care how large the amount is, how small the amount is. If you paid back Cousin Sam $1,000 and then you file for bankruptcy and the trustee finds out about it, and they will find out about it, they're very thorough, then either you or Cousin Sam has to pay the bankruptcy trustee the $1,000. Whereas I absolutely have had people come into my office and say, I've paid Cousin Sam $1,000. And I say, okay, so long as we spotted that issue before the bankruptcy is filed, it's an uncomfortable conversation with Cousin Sam to say, hey, Cousin Sam, can you give me that $1,000 back? I'll deposit it into my account, leave it there. It's protected from the trustee. Then I file for bankruptcy. I get rid of my debt. And then the day after, you're no longer under the jurisdiction of the bankruptcy court. Here you go, Cousin Sam. Here's your $1,000 back. That's an uncomfortable conversation with Cousin Sam, but it's a way less comfortable conversation with Cousin Sam if somebody blew through that issue and now the trustee is saying, not maybe, not might, I want that $1,000, and I'll go after you and I'll go after Cousin Sam, but I'm getting that $1,000 because you made a payment to an insider within a year before the case was filed.
And this is not similar to what we call a transfer, but let's briefly talk about the fact that if you file for bankruptcy, whether it's bankruptcy Chapter 7 or 13, the bankruptcy trustee and therefore the court will very, very, very carefully look at any property you have had that you have transferred to somebody else within the past 3 to 6 years prior to your filing of bankruptcy. In other words, you have equity in your home, or you have your car, or I don't know, you have shares, or your 401k, or whatever it is, anything that you have transferred in the last 3 to 6 years, depending on what kind of bankruptcy you're filing, is going to be it is going to be scrutinized very, very carefully for fear that it is what's called a fraudulent, so to speak, conveyance. Is that correct?
That's correct. Yeah, that's what they call that in bankruptcy court. It's a fraudulent transfer. And the important thing to remember is it doesn't mean that you had any fraudulent intent.
Right.
It's presumed to be a fraudulent transfer.
But now you have to disclose it to the bankruptcy trustee that 3 years ago you gave so-and-so this, or 5 years ago. If you don't If you don't disclose it, although you may have done it very innocently and it was not in anticipation of you filing bankruptcy, you failing to report it might give rise to suspicion on the part of the bankruptcy trustee that this was fraudulent in the first place.
Oh yes, absolutely. You're signing all the bankruptcy petitions, supporting schedules, and statements under the penalty of perjury. When you go to a hearing, a meeting of creditors, you're sworn in, and you say that I've listed all of my assets and everything that I own, all the people I owe money to, and all of those other things that they ask about. And none of my clients ever have, but people occasionally have gone to prison for lying in a bankruptcy proceeding, and there's no reason to do that.
And that's part of what a good bankruptcy lawyer does for her or his client, is preparing them, going over that list very carefully, reminding the client that failure to list something can be very adverse and can, cause you to commit felony and go to prison, and you might as well, disclose it all. It's okay to disclose, but it's not okay not to disclose.
Exactly. Let me give you a very brief example of that. You've got a house in your name. It's worth $80,000. You've got a mortgage that you still owe $65,000 on. So you've got about $15,000 in equity. But someone says, oh, you know what? I'm afraid that the trustee's going to take my house. So why don't I quit claim that house over to my sister or my friend? And then they file for bankruptcy. Well, congratulations. Had you simply kept it in your name, $80,000 market value, you subtract what you owe on it, $65,000, $15,000 you have in equity, that's protected from the trustee because you've got a real property exemption of over $23,000 for your residence. It would have been perfectly fine. Something that the trustee could not have touched. Now the trustee may potentially go after because you've made a fraudulent transfer.
So
talk to a bankruptcy attorney first.
Exactly. So not only were you wrong to think that your house is in danger, you were wrong. Had you consulted with a bankruptcy attorney well in advance of making a transfer, the bankruptcy attorney would have advised you that your house is not in danger. But now you've brought it to the radar of the bankruptcy trustee.
That's correct.
You've created a risk for yourself. That wasn't a risk had you consulted with a bankruptcy attorney, because most of us don't know that. Kind of what you said a bit defies logic, the logic of the lay person. So it's very important that you talk to experts in any field that you are dealing with, not just bankruptcy, not just law. In anything that you encounter in life, it's okay to talk to different people as long as you remember that their situation may be different, they may be uninformed, they may have gotten bad counsel, or they may be right on. Until you speak to an expert, whether it's in the medical field, whether it is in construction, whether it is in the legal field, in any field, unless and until you speak to an expert in that area, you don't know whether you are on.
And absolutely. And I've got to say, even though someone doesn't know the bankruptcy code, when you meet with someone, listen to your heart, listen to your gut. If somebody blows through your facts in 10 minutes and says, no problem, I have all the answers, be suspicious about that, because your life, your financial life is more complicated than blowing through it in 10 minutes and having the diagnosis.
Yeah. Today, we're going to talk about one additional option which sometimes may be available to people who think that their only option, because they owe money, is bankruptcy. I'm talking about debt renegotiation. So the subject today is primarily bankruptcy versus debt renegotiation.
Well, the main difference between bankruptcy and debt negotiation, there's pluses and minuses to both of them.
I do apologize. I called it debt renegotiation. What you mean is debt negotiation.
Correct, yeah. So with bankruptcy, it's supervised by the court. Your creditors they can't decide whether they're going to be involved in the process or not. Debt negotiation is a voluntary process with your creditors.
Okay. So bankruptcy, the courts are involved. The bankruptcy code applies, whatever the consequences are. Debt negotiation is between the person owing the debt or their attorney and the creditor who is owed the debt. It's a voluntary, confidential, private, outside the courtroom avenue.
That's right. There may be times when, for a variety of reasons, a person isn't a good candidate for bankruptcy, but they may be an excellent candidate for debt negotiation.
You told me that owing money to a credit union
that's not a scenario that you can use for debt negotiation. You told me that credit unions, and a lot of people open bank accounts with credit unions because they charge less than typical banks. So people who owe money to credit unions, you've stated to me, do not negotiate down. If you owe them $10,000, that's it. You owe them $10,000. There is no talking them down to taking even $9,000, correct?
That's correct. Think of their whole pitch when you see it on TV or on the radio. We're the local guys. We have our own money, our own skin in the game. We're not some big bank out of New York, but precisely because there's shareholders and because it's a local, smaller organization, it's their own money involved, they don't negotiate the debt in the way that a big bank out of New York would just write off half the debt.
And simply because they can't probably afford to.
That's correct. You take a place like one of the big banks out of New York. That's like the largest vortex of cash in the universe. They're not going to bother to walk down a hallway if the debt's $30,000.
Okay.
If you're some executive.
Okay, so debt negotiation with credit unions is a non-negotiable. That's not something that's going to happen.
That's correct. One of the very first things I look for is, what kinds of debt do you have, and do you have any debt being held by a credit union? And there can be several implications with credit union involvement.
Okay, so walk us through a scenario, maybe somebody who called the office who was considering bankruptcy, but actually you, upon discussion with the client, determined that they may be a candidate for debt negotiation.
Well, the one main dividing line, as you can think of it as Chapter 7 on the one hand, Chapter 7 bankruptcy, and Chapter 13 or debt negotiation on the other. The main difference between those two is someone in a Chapter 7 has little or no ability to repay their debts over time. Maybe they've got $50 left at the end of the month when you subtract all your expenses, your out-of-pocket expenses from your income. That wouldn't be enough to put a Chapter 13 repayment plan together, and it wouldn't be enough to fund a settlement
so
and a
let's
negotiation.
remind the listeners that the difference between Chapter 7 and Chapter 13 is that in Chapter 7, it is determined that you have all this debt and you don't have the ability to repay the debt. So the whole debt is wiped out. Chapter 13, you have all this debt. You have some ability over time to repay some of it. So you go on that payment plan. That's the difference between the two. If you owe $100,000 and you only have $100 left at the end of your month after you pay your mortgage, your insurance, your cell phone bill, your food expenses, you are a Chapter 7 candidate. But if you have some money making ability and you can enter into a partial payment plan, you are a Chapter 13 candidate.
That's correct. And to really zero in on a scenario where debt negotiation may be the best scenario is someone has disposable income that's too high to be a Chapter 7. So Chapter 7 is out of the game. Then you're talking about Chapter 13 versus debt negotiation. Depending on the type of your debt, let's say the guy who had $100,000 he owed to the IRS. One of the things in a Chapter 13 bankruptcy is, now there's different kinds of tax debt. Sometimes the tax debt has to get paid off entirely inside of the Chapter 13 plan. Many times it isn't. But in his case, it had to all get paid inside the plan, and it was more than he could pay. If it's more than you can pay over the maximum period of time in a Chapter 13 is 5 years, then that's a scenario where...
So stretching $100,000 owed to the IRS over 5 years is a lot of money.
Exactly. And again,
that's
I want
$20,000 a year, and that's what, like almost $2,000 a month.
And again, I want to emphasize, many times income tax debt is dischargeable in bankruptcy, which we're going to go over a little bit more in the coming moments. But in his case, he couldn't discharge that debt, couldn't pay it over a 5-year period. Well, the backstop to that is, well, why not voluntarily negotiate the debt with my creditors on the things that I can negotiate, like the credit cards and the medical bills and that sort of thing.
So let me clarify. That gentleman who came to us or called us had debt owed in taxes to the IRS and had debt owed to a credit card company and was not a candidate for Chapter 7.
was a candidate for Chapter 13. So now you have 5 years. You're looking at $100,000 he owes during 5 years to the IRS. And how much were his credit card expenses that he owed?
His credit cards were about $25,000.
So we're already talking $125,000 in debt. Chapter 13, over 5 years.
Right, but now with the credit card debt, even if it's a credit unions can't decide whether they're going to participate or not in bankruptcy. It's only with the debt negotiation that the credit unions don't
are not
work out
interested.
The debt. So, but in the Chapter 13 bankruptcy, if it's a credit card debt, they get paid the least amount and they get paid the last. There's different classes of creditors. They're what's known as a Class 9 creditor. They get pennies on the dollar. Unlike that tax debt, which would have to get paid over the 5 years.
So what plan did you come up with for that potential client, or I don't know if is a client already?
Sure. Well, in the case of, I've had several people I've talked to about tax debt recently. In the case of the guy with the payment arrangement with the IRS, you wouldn't want to file a bankruptcy and undo the payment arrangement. That would indicate...
He already had a payment?
I've had several people I've talked to about taxes recently, but the guy
who
that
already had entered into payments with the IRS.
Some have entered into payment arrangements, some haven't.
Once you are in bankruptcy, this is all dismantled. Cancel.
Correct. So, for example, the gentleman I spoke with yesterday does not yet have a payment arrangement with the IRS. So it makes sense to file the bankruptcy, get rid of all the debt that you can get rid of, and then after he emerges from bankruptcy, then pivot over to working with the IRS to work that debt out.
So how much income does he make? What do you foresee the payment plan to be in a Chapter 13 over 5 years? With $25,000 in credit card and $100,000 owed to the IRS?
Well, there's two real main factors that go into how much you pay into a Chapter 13 plan. You take your income, you subtract your out-of-pocket expenses. What you have left over is how much you have to commit into the plan. But then on the other side, you have all the things that the plan has to pay for. So, for example, someone may very well have $200 left at the end of the month, but if $200 doesn't necessarily pay for, let's say that you're 6 months behind on the mortgage, for example, you'd have to, inside the plan, make the ongoing monthly mortgage payments plus a portion of what you're behind to catch up on the mortgage over time. So you can think of it like if someone was locked into a room and fed 100 calories per day. You could feed someone 100 calories per day. At a certain point, they would starve. So there's two factors. One, how much is your disposable income, and how much do you need to feed the plan per month to make that plan work?
So let's say that this gentleman's disposable income after he pays the necessary expenses is $1,000 a month, and he has to, the original debt is $125,000 over 5 years.
Then the next step is whether he's above or below the median annual income. If he's below the median annual income for his household size, based on the latest U.S. Census Bureau data, he could be as short as a 3-year plan. If you're above the median, you have to be in the plan for 5 years in most cases. So if we're assuming that he's below the median, then he'd be in it for 36 months. And 36 months at $1,000 a month would indicate $36,000. But if his credit card debt, if someone just had credit card debt that was $25,000, then they wouldn't have to pay $36,000. You never have to pay more than everything that you owe to your creditors in a Chapter 13.
So what do you foresee his payments to be monthly?
Well, your payments, if you're in a Chapter 13, are whatever your disposable income is. So there may be a scenario where if you paid your credit cards nothing and you had a mortgage that you were 6 months behind, and curing the mortgage, maybe all told, the amount that actually would minimally fund the plan is $700, but your disposable income is $1,000. The bankruptcy code requires not only that you be able to fund the plan properly, minimally, but also you have to pay your disposable income. So if your disposable income is $1,000 and it takes $700 to catch up on your mortgage and pay 0% to your unsecured creditors over 3 years, you'd still have to pay $1,000.
Very complicated stuff.
You have to pay what you're able to pay over some period of time.
Sure. But this is you doing this analysis, to me, sounds very complicated.
Exactly. That is exactly why, coming back to our original statement, that you can't blow through that in 10 minutes.
As a bankruptcy lawyer. So one option for some people can be debt negotiation in lieu of bankruptcy.
That's correct.
Okay. And debt negotiation is somebody comes to you and you analyze their situation and you say, you know what? I think maybe we can avoid you having to file bankruptcy and we can negotiate down your debt. And you send a letter to the creditor or you send an email to the creditor that begins the discussion. And now the creditor is less likely to send this to their collections and less likely to file a lawsuit because they know they are dealing with a lawyer. They know that the debtor has hired and paid for a lawyer to represent them in taking care of the debt. And so they're less likely to go into the expense of filing a lawsuit. That will buy you and the debtor, the client, time. It can be 6 months. You said sometimes you have seen this negotiation back and forth between you representing the person who owes money and the institution that is owed money as late as a year or a year and a half. During that time, the debtor client stops making payment on the debt, whether it's a credit card or anything else, buys time for 6 months, year and a half to come to a good negotiation. And let's say you start with a $10,000, credit card bill, takes you 6 months to convince the bank to reduce it to, you said to me typically in debt negotiation, it's 45 to 50%, correct?
Yeah, it's in that area, 40 to 45, maybe 50%. It depends on the creditor.
Call it then a $10,000 credit card that you've been negotiating on with the attorney for the bank and was able 6 months out to reduce it to $4,500. During that 6 months, our client did not pay anything on the credit card, but then at the end of the 6 months must come up with a full payment to pay in full the $4,500, correct?
Exactly. And then someone may only have $400 left at the end of the month and they don't have the ability to pay $5,000. But the whole debt negotiation process is premised on the fact that you're not paying the cards anymore during the process.
So it buys you time. So you hold on to that $400 and you let your lawyer do the negotiation. It's 6 months later, you've already come up with $2,500.
That's correct. And over a year or so, if you had $400 per month, you would be able to fund that settlement.
Exactly. And why would the banks or any creditor be interested in even taking your call and wanting to negotiate with you? Because what is the one line that you tell them all the time?
Well, the one stick is we also do bankruptcy. If we can't work this out voluntarily, many people are reluctant to file for bankruptcy. They try to do debt negotiation first. And if debt negotiation doesn't work and we can't work out a mutually acceptable deal, they always have the fallback of filing for bankruptcy. Then you may get much less, you may get nothing.
Right. And if so, you tell them, if you do not meet me halfway, my client will file bankruptcy. And if my client files bankruptcy, if they do bankruptcy 7, you're getting 0 out of that $10,000. And if they do Chapter 13, you will still get a lot less because you're last in line as a credit card company among all of his debt. And you will get a lot less than the 40 to 45% that we're hoping that we can walk away with. And that gets us listening.
Absolutely.
That's much more guaranteed than leaving the client to her or his own devices and filing bankruptcy and having the creditor be paid 0 or much less than the 40 to 45%.
Absolutely, Joumana. And a debt negotiation is a mutual negotiation between the parties. The creditor has a lot less leeway in bankruptcy. There's certain amounts that they're going to get, they're not going to get, different classes of creditors. That's attractive to creditors because it's a mutual negotiation. They have a lot less a lot less authority, a lot less control over the bankruptcy process.
And Rami, if we can take a very, very quick break so that we can catch our breath. And before the break, I just want to say, and the nice thing also for clients is then they can avoid bankruptcy. We talked plenty about the self-imposed and the social stigma of bankruptcy. We're not even talking about that. We're talking about, the stress of getting people to call them and the their credit score going down. And of course, in an ideal world, if we can resolve our financial problems without needing to file bankruptcy, that is absolutely the preferred number one go-to solution. Correct?
It's definitely a solution. Again, it depends on the individual.
Sure, it depends on the circumstances and on the individual. But I'm saying all things being equal, if we can help somebody resolve her or his financial problems through debt negotiation, this still remains an advantage over a superior alternative to filing bankruptcy.
Yes, that's a very good option in many cases.
Okay.
فاصل غنائي ونعود بعد قليل لبرنامج يور رايتس مع المحامية جمانة كيروز. أهلا وسهلا فيكم مستمعينا مرة أخرى. عودة لبرنامج يور رايتس مع المحامية جمانة كيروز
والمحامي مايكل بنكستين اللي هو رئيس الديبارتمنت تبع البانكربسي في المكتب واللي is doing a phenomenal job both on the air and in the office.
شكرا جمانة.
You are welcome, Michael. Michael, before the stop, this is a very good discussion, yet another very good discussion today. Let's talk about, and I know the answer is not yes and is not no, and the answer is it depends. When you owe the government, whether it's the IRS or the state you are in, taxes, can you file for bankruptcy and have it go away? Yes, no, depends. Maybe we can defer, we can freeze. It's all of that.
Yes, it depends. One major dividing line is...
That depends. That's such a lawyer answer. It depends.
Well,
now let's explain.
It's a lawyer answer because it's a life answer, and life really does depend on the facts. In your tax situation, generally speaking, if the tax returns were timely filed, in the
year before. So we are 2018 and our taxes should have been filed by April of 2018 for the previous year.
That's correct.
Okay, and we're considering filing bankruptcy today. So if our 2017 taxes for which we owe taxes were filed timely, meaning by April 2018, then what?
Well, in that case, it still wouldn't be dischargeable because there's really a two-part thing you want to look at. One, were the tax returns timely filed? And two, was it 3 tax years ago or greater? So if you're trying to file a Chapter 7 bankruptcy in 2018 to get rid of 2017 taxes, that's not dischargeable. That would be considered a priority debt, which is not dischargeable. If, for example, though it was a debt for 2013, let's say you've got $10,000 in tax debt from tax year 2013 and the tax return was timely filed. That's a case in which in the Chapter 7 bankruptcy, it would be dischargeable.
So then, depending on certain facts, taxes owed to the government, whether it's federal or state, may or may not be dischargeable depending on what year we're talking about and whether those taxes for that year were timely filed with the government.
That's correct. And there's a couple other things, too. Every now and again, the IRS will file a notice of intent to levy. And if they actually have a levy on it, it's a form of a lien. That makes it a secured debt rather than an unsecured debt, even though it's secured in your personal property. That kind of debt may not be dischargeable in a bankruptcy.
Okay. And we sometimes reach out to tax attorneys who can help us with our clients who are facing a tax situation. Can you tell us about that a little bit more?
Oh, yes, absolutely. I had someone who was just a few days away from a foreclosure sale, so she had to file a Chapter 13 bankruptcy to stop the foreclosure sale and catch up on the mortgage over time. That absolutely made sense. Wouldn't do anything for her tax debt. She
owed the government taxes?
Yes.
How much?
She owed about $13,000, and that debt was not dischargeable. So normally under the Chapter 13, she would have to pay that over a 3 to 5 year period in full. But I was looking over the tax returns, and I asked her, did you do these taxes yourself, or did you have someone do them for you? And she did them herself. I'm no tax expert, but I said, you may want to talk to our tax attorney, our affiliate who does taxes, to look this over. He looked over her returns. She was able to amend the returns and reduce that debt by several $1,000s.
So was that the Silver Law Group? Chad
yes,
Silver?
Absolutely, Chad Silver.
Okay,
Silver Law Group.
And was it that she did her taxes wrong and she really owed less? Is that how he came in to help?
She did them on her own. And they weren't correct. She hadn't stated some of the tax credits and some of the tax deductions that she had. Some of the formulas she filled out incorrectly.
So he was able to reduce that debt below $13,000 because she did them wrong in the first place.
That's correct, because the bankruptcy court is the gatekeeper. The bankruptcy court gets a proof of claim from the IRS saying you owe such and such based on your returns. But
they don't care. So if the IRS says sorry, she owes $10,000, not $13,000. The bankruptcy court is okay with that.
They went off her returns, and so the Silver Law Group helped her to amend her returns so the debt was lower. When the debt was lowered, the IRS amended its proof of claim in the Chapter 13 bankruptcy, and then that was $3,000 less she had to pay to the IRS over the life of the bankruptcy.
Is that advice you would also give people who are facing a tax situation and are filing for bankruptcy, even if they had their taxes filed by a so-called expert, having somebody else take a look at them to see if they can be reduced, if an error did take place? Would you give that advice?
I would always say, since I'm not a tax expert, it's always a good idea to talk to a tax expert about your tax situation. Although, if you've got a Chapter 7 bankruptcy and it's an older tax debt that you can discharge, it might not be worth it. But there are definitely many, many situations in which, if it's a game changer, for sure, it's always a good idea to talk to an expert in that area.
Okay, so older tax debts may be dischargeable in bankruptcy. Newer tax debts are not dischargeable in bankruptcy. However, maybe, just maybe, you owe the government less than you think you owe, so it merits, since it's not going to be dischargeable in bankruptcy, having another set of expert eyes, even if they were prepared by an accountant, having another set of eyes, because maybe, just maybe, you can reduce those taxes owed.
Absolutely, and that's the important thing to remember. We have a number of attorneys and affiliates, each of whom specialize in a particular area. We take a team approach to treat the whole person, the whole situation, in a way that sometimes the standalone bankruptcy office just can't do.
And we have about 2 minutes. We talked about how some taxes owed to the IRS or to the state you live in may be discharged in bankruptcy or may not be discharged in bankruptcy. It's a case by case. It depends on the years. It depends on whether your taxes were timely. Very quickly, student loans, most people, including myself, thought that student loans are not dischargeable in bankruptcy, and when we had that discussion before the show and in preparation for the show, you said to me, nope, it depends, and there may be alternatives. It's not that they are not discharged or discharged, it's that you can kind of, depending on your situation, freeze them for now. So if I owe the government $500 every month in student loans and my situation has changed and I'm filing for bankruptcy, you may be able to get me to pay zero for right now, correct?
That's correct. Even though the student loans generally are not dischargeable in bankruptcy.
Government or private, by the way?
Generally, whether it's government or it's private, it's not dischargeable in bankruptcy. But in this case of the government loan, you may have some deferments or some forbearances
So what
available.
does that mean, deferments and forbearances? If I have to pay $500 a month and I'm applying for bankruptcy, does that mean that you might be able to put them on hold for me right now?
Correct. In either one of those cases of a deferment or a forbearance, you wouldn't be paying for a time. The main difference between a deferment and a forbearance is in a forbearance, the interest is still running, whereas in certain deferments, the interest will stop running.
Okay. And again, in 30 seconds or less, let's remind people about what we talked about last time. When you get Social Security payments from the government, such as SSI, please make sure that you have a bank account that the money gets deposited in, and you do not deposit any other funds from any other source, however small, even if it's $10, into that account. Create another account, because you do not want to commingle those Social Security funds with other funds, because if you do, then maybe you will be subject to collection and somebody can garnish them, much like they can garnish wages and property and everything else should you be sued.
That's correct. They can garnish you. If they have a judgment, your creditors can garnish you for up to 25% of your gross wages. One exception to that is you can't garnish Social Security funds.
But not unless you put them in an account that has all kinds of funds coming into it.
Exactly. That's for every move, there's a counter move. If you put a bunch of Social Security money into a bank account where other sources of income are going in and coming out, it loses its identity as Social Security income. Even though they couldn't have garnished the Social Security income, now because it's commingled funds, they can hit your bank account. So you want to make sure you have that in a separate account.
Attorney Michael Benkstein, that was another wonderful, extremely helpful 1-hour session to our listeners. Thank you so very much.
Thank you.
Rami, thank you very much. Thank you to all our listeners. And God willing, until next Thursday.
إن شاء الله. تحياتنا لك جمانة. Thank you Mike.
شكرا
Thank you, Rami.
لك. شكرا
مرة
للإذاعة.
أخرى.
لكلكم.
شكراً،
يعطيكم
جمانة.
ألف عافية.
الله يعافيك. شكرا مرة أخرى.